What you need to know about contract law before signing that bad boy. Congratulations, you finally got the offer. All those sleepless nights and months of smoking pot on your couch are paying off. But before you sign that piece of paper, take some time to understand what you're signing. The piece of paper that they will want you to sign is called a contract. A contract is a legally binding agreement which recognizes and governs the rights and duties of the parties to the agreement. The history of this is long and complex, but is important to know in order to understand what you are signing. We recommend purchasing Employment Hunter International's 22-volume set on the origins of contract law in order to fully familiarize yourself with the details of how English contract law, on which American contract law is based, is rooted in the Norman invasion of England in the 11th century. For now, simply understand that a contract is legally enforceable because it meets the requirements and approval of the law. A contractual agreement typically involves the exchange of goods, services, money, or promises of any of those. In the event of a breach in the contract, the law awards the injured party access to legal remedies such as damages and cancellation. In order for a contract to be formed, the parties must reach mutual assent, and each party must have the capacity to enter into the contract. This is typically reached through an offer and an acceptance, which does not vary the offer's terms. An offer is a definite statement of the offerer's willingness to be bound should certain conditions be met. If a purported acceptance varies the terms of an offer, it is not an acceptance but a counteroffer and, therefore, simultaneously a rejection of the original offer. The Uniform Commercial Code, also known as the UCC, disposes of the so-called mirror image rule described in Section 2-207, although the UCC only governs transactions in goods in the USA, which generally renders it irrelevant to the terms of an employment contract, and is thus not even remotely relevant to this conversation. However, a contract of employment is usually defined to mean the same as a contract of service. A contract of service has historically been distinguished from a contract for the supply of services, the expression altered to imply the division between a person who is employed and someone who is self-employed. The purpose of this division is to attribute rights to some kinds of people who work for others. This could be the right to a minimum wage, holiday pay, sick leave, fair dismissal, a written statement of the contract, the right to organize in a union, and other such concerns. The boundaries of a contract of employment is complicated by the use of many other sorts of contracts involving one person doing work for another. Instead of being considered an employee, the individual could be considered a worker, which could mean less employment legislation protection, or as having an employment relationship, which could mean protection somewhere in between. Because of all the complicated nuances and legal stipulations surrounding employment contracts, we recommend not bothering to even read what you were given, and just signing it so you can begin collecting your paychecks.